We're on the record.
We are on the record. All right.
This is the meeting of the Sunshine Ordinance Task Force Education Outreach and Training Committee for October 17, 2017. The time is 3:35 p.m. On the call of the roll, Member Eldon.
Present.
Eldon present. Member Fisher.
Present.
Fisher present. Chair Wolf. I have been informed by Chair Wolf he is on the way. He had a little difficulty with traffic and he'll be here shortly. Would you like to note that I believe that Member Fisher will be acting chair until Chair Wolf arrives.
Noted.
There are no agenda changes that I know of today.
There were no requests for changes?
No.
Thank you.
Next on the agenda, item number 2, adoption of minutes from the August 15th Education Outreach and Training Committee meeting.
I went through them, and I don't have any changes. Do you, Member Eldon?
Nope.
Okay, so then I make a motion. What do we do? Make a motion that we accept the minutes?
Seconded.
Is there any public comment on the
I was
minutes?
going to ask that. Any public comment on the minutes that we have just motioned to be accepted? Hearing none, move on. I just like
That motion passes. The
Okay.
minutes are adopted.
Okay, Mr. Young, can you call the next item?
Next on the agenda is item number 3, public comment. Members of the public may address the Education Outreach and Training Committee on matters that are within the committee's jurisdiction but not on today's agenda. Is there any general public comment today? There does not appear to be any at this time.
Hearing none, Mr. Young, can you call the next item?
Next on the agenda, item number 4, file number 17078, complaint filed by Patrick Manette Shaw against Jay Hughes, Norm Nickens, and the Board of Trustees, San Francisco Employee Retirement System for allegedly violating Administrative Code, Section 67.7A, 67.14B, 67.15, and 67.34 by willfully failing to post an agenda listing proposed actions or statements that the item is for discussion only, failing to provide complete audio recording of the meeting, and failing to provide an opportunity for public comment. This is regarding the May 22nd, 2017 San Francisco employees regarding the May 22nd, 2017 Board of Trustees special meeting.
Member Eldon, do I have a motion for jurisdiction?
Can you pull a mic? Yes. Yeah, that's good.
Keeps falling.
You have a motion?
I will make the motion.
I'm going to second that because I saw that our city attorney said that, because I was wondering about this, said that the SF FERS actually is within our jurisdiction. So
Okay.
I'll second that motion.
Is there any public comment regarding the finding of jurisdiction over the SF PERS? There is no public comment. Would you like to approve that without objection?
Yeah. Let's do
That motion is
Thank you.
approved without objection with Chair Wolf being absent.
So who is, well, were you ready
I
to hear
believe
the,
Mr. Manette Shaw is present.
who is our respondent, though, for this? Who's, okay, so we have both. So, Mr. Manette Shaw, you've been here before. You know how this goes. We're going to have Ms. Young 5 minutes each.
3 minutes at committee level.
Oh, well, 3 minutes, okay. Did not know that. So you'll get 3 minutes. You have 4 items, though.
No, this is single.
This is one item, but
Yes.
there were 4 parts to it.
That's the next ones.
Oh, sorry. I read ahead.
Why
So
is
you-
it only 3 minutes instead of 5? I don't get it.
Can we go 4?
It's standard for everybody.
Go ahead and let's see how things go.
Just note, if you provide 5 minutes, you have to provide 5 minutes for everyone today.
No.
Let's go with 3 minutes then and see how it goes.
It's however it is for everybody all of the time here.
That is the standard time limit for committee hearings.
Okay.
Thank you. On the first cause of action about the incomplete audio recording, the 2 audio tapes of the retreat omitted discussion of 15 PowerPoint recommendations, omitting recommendations 18 through 32. On page 10 of your packet, in the first bullet point, I noted 3.5 hours of a 6-hour meeting were not recorded. The meeting started at 9. The first audio tape ended 1 hour and 36 minutes into the meeting. They went on break. That tape was never resumed between 10:37 and noon when their hour lunch was scheduled. There's about an hour and a half gap on the first MP3 audio file. The second tape totaled just 54 minutes. If the afternoon session was scheduled for 3 hours between 1 p.m. and 4 p.m., the 54 minutes suggests there was clearly a 2-hour gap on the second file. Mr. Nickens' July 17th response admits the morning session was not recorded between 10:30 a.m. and noon. It's the last paragraph on page 38 of your packet. His response also noted that the afternoon session was fully recorded. It's the first paragraph on page 39 of your full packet. That is totally incorrect. The afternoon session was not fully recorded. And it could not have been recorded within 54 minutes. Your DCA COLA's instructional memo reported that the retirement system had paused recording equipment following the lunch break. That's absolutely incorrect. It was paused during the morning break. In the smoking gun memo in the smoking gun section of my initial complaint, I noted the length of both of the two MP3 files. As you can see on this chart, that it totaled just 155 minutes of what should have been a 360-minute meeting, indicating 43% of the meeting was recorded and 57% was not. The smoking gun section also documents that the first MP3 file was created and date time stamped on the same day of the May 22nd retreat, but mysteriously the second MP3 file was dated with the date time stamp of 2 days after the meeting was held. I alleged on the second cause, I alleged there were two versions of the meeting agenda. There were actually...
Mr. Minette Shaw, can you summarize, can you complete your thought? You'll have a chance to come back and speak more.
I know, but I was hoping for 5 minutes here and 3 minutes on the other. Can I please try to get through some more of this?
We can't make exceptions. It's the same for everyone who comes up here, and it's
This is
the
frickin' ridiculous.
rules.
Let's hear what the respondent has to say, and then you'll get some time during Q&A. Is there anyone that wants to,
No, we
what's it called? We don't do that here?
No.
I was all excited. Okay, come on up. And since you're the respondent, you can give us your name, please.
Norm Nickens, Retirement Board Secretary. Madam Chair, members of the committee, pleasure to be here. I believe this is the second or third time I've been here with Mr. Monet Shaw. I will be brief, just by way of context. The Retirement Board, the pensions fund for the city and county of San Francisco, generally meets once a month. In May of this year, we actually delayed the start of our normal meeting, pushed it back a week due to a conflict with an event that a number of board members were attending. We held a regular board meeting on May 17th, Wednesday, May 17th, followed by a full board retreat. Monday, May 22nd, followed by a full board investment committee meeting on Tuesday, May 23rd. That's context is we did 3 full board meetings within the context of 5 days. Now, that having been said, in regard to the allegations, first the allegation that the audio recording was not complete and that was willful, we agree in part. We agree that the audio was not complete. Mr. Monet Shaw filed a public records request for the audio of the meeting. We immediately produced the audio. Thought nothing of it. I honestly had not reviewed the audio because we just had 3 days of meetings when his request came in. In the past, for our off-site retreats, we'd used a handheld cassette recorder. The sound quality on that is horrendous. This time we decided to get a new recorder, a digital recorder, which arrived the Thursday prior to the meeting. I used it for the first time the Friday prior to the meeting, and we used it starting at the board meeting in that Monday morning. It appears what happened was the board meeting started after breakfast about 9:15. We went until about 10:20, took a break. I stepped out to get the coffee, tea, etc. for the break. Apparently while I was out of the room, it appears someone hit the pause button on the recorder. I came back in, honestly didn't notice that. The meeting went on until probably, I'd say, about 12:15 when we took a lunch break. We had a rather extensive lunch break. One of our board members treated the board to lunch, and we had a rather extensive lunch. The lunch break ended at approximately shortly after 1. I noticed at that point something didn't seem quite right with the recording device. I did a couple of tests to make sure it was recording properly, and then we recorded the afternoon session. The afternoon session ended shortly after 3 o'clock. So, did we make a good faith effort to record the meeting? Yes. Were we successful? No. That's point number 1. Point number 2, the agenda. The allegation is that there were 2 agendas. We agree in part. When we sent out the initial board packet for the Wednesday, May 17th board meeting, we included in that materials for the May 22nd board retreat that included an agenda and the report on the board self-evaluation. Shortly after we sent that out, we realized the board member, or in further consideration, we realized board members had not seen this very detailed report, wouldn't have time to respond to it, so we published an agenda for a discussion-only item, distributed that to the board, held a discussion-only meeting at which public comment was taken.
So, yeah, I'm going to have
That's
to
it.
cut you off there. Okay. Thank you. Q&A.
Yes. I would suggest that you ask the parties to address the issue of the failure to post an agenda listing proper action for the discussion only item, as that hasn't been addressed completely by either party at this time.
Yeah, no, am I reading this right? There's 3 or 4 different.
There's one regarding the posting of an agenda,
Okay. Yeah.
one regarding the audio recording, and one regarding the failure to provide for opportunity for public comment.
So there's 3 complaints in here.
Okay.
3 issues at stake.
I
Yes.
understood the audio recording. I think everybody's heard that. You said,
There's one complaint regarding the agenda
okay.
item.
And the public comment, that's, I mean,
That
I
hasn't
read,
been addressed by either party
yeah,
yet.
I read that. That seems pretty straightforward. Mr. Manette Shaw, can you tell us if there's something about that public, I'm going to start with the easy for me, the easy one. The complaint about the public comment, because I don't think you got to that. And then I'm going to.
No, I hadn't actually, and I do want to address the multiple agenda items.
We're going to do that next. I'm trying to break this down and keep it as simple as
All right, so
possible.
to answer your question, on figure 2, which is on page 12 of your packet, in my initial complaint, I alleged that there was no separate general public comment period. So DCA COLA's memo to you that I had alleged that they had not taken public comment at all was COLA's incorrect interpretation. I was referring in this third cause of action only to the fact that there was no general public comment period listed on the agenda.
Oh, okay. So there was, okay. I'm going to ask Mr. Nickens to speak to that. I'm trying to break this down as simply as possible. For me, everybody else is probably 3 steps ahead of me, but.
I think your original question was actually on the issue of the agendas. As I mentioned...
No, my initial question was on the public comment.
Oh, sorry.
That was the simplest one, too.
Okay.
Because as I read through this, there was public comment,
Yeah.
and there was only one person there, and so I just want to know, did Mr. Manette Shaw miss it? Did it not happen? And then we'll get to the agenda one.
If you listen to the tape, the very first thing you hear is the president of the board saying, is there anyone here who'd like to speak under public comment? There was one individual from the public in the room, Sharon Breslin from the Health Commission, from the Health Services Board. She was asked if she wished to comment. She said no. We closed public comment.
Okay. And it now.
The point is, it wasn't listed on the agenda.
Oh, okay.
It was discussion-only
Mr.
item.
Okay.
However, we took public comment. And
Okay.
I should mention, in addition, Mr.
We'll
Monet
get to
Shaw
that.
did
Yeah.
submit written public testimony the Friday before the meeting, which was distributed to the board within an hour of receipt.
Okay, thanks. You can sit down. Victor, you had something helpful here.
The third item was the failure to post an agenda listing proposed actions, or a statement that an item is for discussion only. That
Okay.
hasn't been addressed.
Mr. Manette Shaw, would you like to address that?
I allege there were at least 2 versions in my supplemental to submitted on August 13th, which is page 28 in your packet. There were actually 3 different versions of it. The first one is what was presented to the Board of Trustees prior to the meeting, indicating that it would be an action item. Board members may have entered that meeting under the impression that they were addressing an action item. Version 2 provided to members of the public that it was a discussion item, was prepared 3 days later after the version given to the board. As a reminder, on pages 34 to 36 in your packet is material from Board Trustee Victor Macris documenting his concerns over the 2 separate agendas, in which he notes he was not, quote-unquote, confused, as SERV's staff tried to pass off. There were multiple versions of that agenda.
Okay. Thanks, Mr. Minette-Shaw. Yeah, come on. Come on up, Mr. Nickens. 'Cause now I'm confused. I'm reading this,
No
too.
problem. I believe the relevant agenda is the posted agenda that was posted on our website and distributed to the public.
And which...
That was the agenda that was distributed on I believe it was Monday the 15th, and that agenda indicated that it was discussion-only meeting. In the board packet that went out the Friday preceding, we did include an agenda that did indicate it was going to be an action item. And again, as I mentioned, after further discussion between Friday and Monday, we realized that was too much to take on for the board, and we informed the board at the meeting on Wednesday the 17th that we would hold a separate meeting in order to take action on the item. We posted an agenda that said it was discussion only. We held a meeting in which no actions were taken. We held a follow-up meeting in July that was an action item, at which point the recommendations that had been presented at the first meeting were considered and acted on. Happy to answer any questions you may have.
Member Eldon, do you have any questions?
I'm just trying to understand.
If we had posted the original agenda that was distributed, the appropriate action at that point would have been to post a revised agenda.
Okay, so...
If I had to do over again, I might have done that. However, the only people who saw the first version of the agenda were the 7 board members who received it late Friday afternoon. Monday morning, when we posted the discussion-only version. When we mailed out the agenda to our interested parties list, et cetera, we mailed out the discussion-only version. So to the public, anyone who's interested in attending the meeting, they would have seen the discussion-only version.
Okay. So
I believe a brief summary of that was that
Please.
an agenda was created on the Friday. It was not distributed to the general public, only to members of the committee. And then on that Monday, they, in essence, revised that and issued a different agenda to all parties.
on Monday
Is that
Correct. Yeah, I don't dispute that.
for a meeting that was happening on,
The following Monday.
oh, so it made the 72-hour cutoff.
Correct.
then.
And
Okay, I was-
we had previously posted the notice of an off-site meeting 14 days in advance of the meeting.
Okay, so, you changed some things. Change is
I believe
constant.
the question would be, if the members received it, is that an official calendar or not?
Oh, that's a very good question. Something that I would ask an attorney who's not here.
I missed that question. What was it?
Isn't it?
If it was distributed to the members, is that considered an official posting if it's not distributed to the general public?
Oh,
Or is it kind of like a draft agenda?
yeah, I would see that as a draft agenda. That's how I'm
I
unpacking this.
will not comment on that portion.
No, okay, but
Yeah.
I can, because they can yell at me later. But, I'm going with there's the letter of the law and the spirit of the law here, and since I am not an expert on agendas, but if I would see that logically and reasonably as a draft agenda.
Yeah.
You
Again,
send
as I
something
mentioned,
out afterwards.
had we posted and distributed the agenda to the public, the appropriate
Yeah.
action would have been to issue a revised agenda.
Yeah.
But as the 7 board members were the only people who had gotten it the Friday before, we didn't. If I had to do it over again, I probably would have put revised on it.
Yeah, okay. I can live with that. And Chair Wolf is here, so I am here. Here's your gavel.
Through the acting chair and now
back to
becoming
you.
the chair. Quick question, sir. So the meeting agenda went out to the members. Is the agenda posted online somewhere?
Yes.
And was it posted online in the version that went to the 7?
No.
So the only possible people that could have received or seen the initial agenda were the 7 members and anyone that the 7 members may have forwarded it to, which you would have no knowledge of.
Correct.
All right. Mr. Shaw, can I ask you a question? Yes. So apologies for coming late. I got stuck in traffic. But in what I'm hearing at this point, I'm trying to understand how did you become aware that there were these 2 different agendas in the first place?
I'm not going to answer that question.
Okay. Which version?
Because my recollection is that first agenda saying, or that it was a action item had gone out. People were aware that it was an action item. And I'm not going to tell you which people were aware of it, but I became aware of it fairly rapidly, even before the online versions changed it to being a discussion item. So I knew about it. It wasn't just that only the 7 retirement board members knew about it. Others knew about it as well.
Okay, thank you.
I mean, it's within the rights of these types of organizations to change their agenda before the meeting, provided they update the public. They did do that.
Why wasn't it marked as being a draft agenda? It wasn't marked as a draft agenda. It never was marked as a draft agenda. When those retirement board members got it and were not confused by it,
I mean, what's the specific?
it was not marked as being a draft agenda.
Chair Wolf?
Yes?
I'm
You have a question? Go ahead.
No, I kind of have a statement. I hear you, but I think we also heard Mr. Nickens say you kind of admitted that you would do it differently next time. So I completely agree with you.
Well,
Fix it
This
next time.
isn't about the next time.
Yeah.
This is about what happened.
Well, I'm just trying to find. I don't think that's actually specifically in the ordinance where you have to mark it draft if you're not sending it out. I mean, I'm having trouble finding that exact violation that you're looking for there. They updated the agenda with changes, and that's what made it to the public more than 72 hours.
Okay, I don't have a laptop with me, but I distinctly remember that agenda saying that it was a discussion item that I found on the internet was not a week before the meeting. It was the Friday before. The Friday before, or the Thursday before the May 22nd meeting was when it was available online as a discussion item. And so as a retired former city secretary, I was required at the Department of Emergency Management to make sure that that their agendas for the mayor's disaster council were posted 72 hours in advance. And my job was to nag the staff to pull together the agenda so that I could get it to the public library, get it posted online, get it sent to interested people's emails. And I don't recall us ever having issued an agenda and then issued a corrected agenda saying that the first one was a draft, but here's the final one, right? It doesn't happen. I can't believe that when I was paid half of Mr. Nickens' $135,000 salary as of last June 30th, I never made those mistakes, and I can't believe, A, that someone highly paid like him would have an error like that and not mark one or the other draft or final or corrected agenda. And my understanding is when those trustees went into that meeting on May 22nd, they were under the impression that it was an action item. As Trustee Macris's written documentation in your packet that I gave you the relevant page numbers of indicate. Do you want those page numbers again?
No, I think we're good. Do we have?
I was just, would you like me to summarize the previous discussion for your benefit at this time?
I think I actually understand what's happening here. Can you repeat the question that you posed to us that you weren't about to answer, but I want to memorialize that if we can?
The question, if I recall, was they issued an agenda. It was not. They did not believe that was distributed to the general public and only distributed to their own personal members. Did they need to submit it as a revised or corrected agenda on the following Monday?
Right. That's the larger question. I believe you said something along the lines of, did it become an officially notified meeting when they sent out the agenda to the members?
That is correct.
That's the part that I would like to memorialize and have us revisit with the full task force, because if this were a private corporation and they sent out a letter to the Board of Trustees and then they made a new one and said, throw the old one out, like, that's whatever. But because that first document was intended to be an agenda, it became a public document at that point. And so we do have two documents that are in conflict with each other. The reality is that some people were notified.
I disagree, but go on.
The reality is that some people were notified based on this initial document that was apparently not clear that it was only a draft to be changed later. And so I think that these issues should be looked at amongst the full task force. But I see one of my colleagues disagrees, so go ahead and jump in.
I respectfully disagree with you on this, because this, according to Mr. Nickens, went to 7 people, and so the word public was not in there. It wasn't sent out to the public yet, so you just kind of shoved the word public in there. So I mean, maybe
He's saying it is inherently a public document if it went out to those people and the member.
And I was eventually provided.
I'm not done yet. I don't think it was personally, and we could be 2-1 on this. We disagree all the time, but I don't think it was a public document.
It's a public record. It's a sunshine public record.
It's a public record. I'll give you that.
That's all we're saying.
It's a public
Okay,
record,
so
but
maybe
I don't
if there's
think
a
it's a public
difference
agenda.
Yeah.
I don't know whether the difference between a public document and a public record, but I will change what I said to public record if there is a difference
I'm okay with it being a public record, but
But there's the issue of if they give it to the 7 members, they are, I hate to use the word, they are working together to set an agenda, which is not allowable. If they only send it to the members and they work together to change it, that's a different violation.
that's a whole other violation then.
Right. So
Better dig deeper here.
I think some of these issues can be better explored with the full task force, with our legal counsel present. I see definite concerns. The department itself acknowledges that they would do it differently in the future. I'm not sure whether either of my colleagues wants to actually make a motion of a specific violation at this point.
There's a violation here. I just can't seem to find it.
Well, there's multiple potential violations.
And what about the rebuttal period?
There's 3 different
We
issues.
haven't gotten there yet.
There's one. Just going from the top down, right? There was the recording problem.
What would that? I'm on.
The first cause of action here, which is, to me, clearly a violation.
I know, but I can't match it to like 67 dot dot-
14B.
What? 14, you're saying?
4B.
Can someone summarize
14B?
the testimony that occurred about the recording? Because I had not.
Yes.
Basically,
Well-
they for some reason, there was some accidental error where there was this offsite that was being recorded, but the recording, somebody had paused it for some reason.
We call that fumble fingered it.
Yeah, something happened where it cut out. There's another question we haven't gotten
14.
to yet, where the afternoon session that was supposed to be recorded only lasted 53 minutes, even though that session, at least on the calendar, went a lot longer. And so there appears to be some missing information there. We haven't really dealt with that yet. But, I mean, to me, it's pretty clear, and everyone here seems to agree, that there is, let me just, 67.
14, I like B and C. This one.
Yeah, I mean, it's pretty straightforward that it should have all been recorded and provided to the public.
And
So
let's just,
that is a
take 'em
clear violation, and I'm ready to make a motion if we need to there. For the second one, which is the two versions of the meeting agenda, I feel the same way right now. I don't have a really good understanding of what should have been done there. And maybe we should submit that to the city attorney for their opinion more specifically on this ahead of the general session to discuss. And the third one, which we haven't gotten to, was no public comment period listed on the agenda.
on the agenda. They
I
had the public
believe
comment.
the code does state, under 67.15A, every agenda for a regular meeting shall provide an opportunity for public to directly address the policy body.
And I think all of that needs to be on the agenda. I mean, just as a matter of practice.
It was not on the agenda.
That's what it looks like.
I'm
So to me, there are at least two, there's one clear violation, another probable violation, and then the third one, which we're uncertain about,
So-
regarding the dueling agenda.
So unless we have a way to include the dueling agenda issue in the motion, I'm a little concerned about having a specific recommendation of the other violations, because I've seen in the past that the issues that were ambivalent ended up just getting overstepped with the full task force. So I would prefer that whatever motion we make either specify some violations, but not, we recommend finding violation and allow the full task force to identify, or somehow parse off that piece that we're still a little uncertain about so that it doesn't get left behind.
Victor, do you have a recommendation?
You can recommend a violation for those two and make a suggestion that we could not, on the third one, that you could not come to an agreement on that third violation. You request that the full task force address that further.
Sure. I mean, the full task force ends up addressing the whole thing because it's basically a de novo
Yes.
hearing anyhow. Whatever people feel is
We can give them the two options of why we think we can't decide.
Can we set it up, because Chair Wolf made a really good point last
We
week, that he
can-
wants us to come to the full task force with as much solid information and recommendations, so we can go in, can we, let me pose this as a
We
question.
can have the question, and, upon receipt of an answer to this question,
Right.
we will be able to provide a decision, or give both sides. Say, one, we believe that it was properly noticed, even though, I believe the question is providing it to 7 members an official public notice, and does that need to be revised or not?
I'm actually going even one meta step above this. Can we go in, my colleagues and I go into our next meeting and say, okay, boom, item 1, we see this violation. 2, we see this violation. Let's not spend too much time on that. Here's the thing that we have the question about, and then go from
I
there.
can note it however
Thank
you
you.
like in the minutes.
Because I just don't want us to unpack this whole thing and spend 45 minutes
Yeah,
reviewing what we've
yeah,
done.
I
I
mean-
want to show that we've done our job here.
I mean, we could spend more time exploring the ins and outs of this. I mean, there's a fourth point that the complainant has brought up, which is willful violation. And looking through the packet, I mean, there are 4 different, basically, complaints packed into one here, which is why it's...
And what about the rebuttal period? So I
haven't
can
gotten
get
there.
to the 4th willful violation thing.
So
Chair Wolf?
the actual process for the complaint committee is a little more informal, but I think that you have a need to speak to this issue, and we should provide that. So
I'd just like to say regarding willful violation, we usually don't make recommendations regarding willful violation, as we don't have authority to make that determination.
I want it
That's
on the
an ethics
record
committee.
because the 5-minute opening got cut to 3. I expected
Mr.
the
Bennett Shaw,
regular
I'm-
procedure of a 5-minute opening, 3-minute rebuttal would be heard at this committee, and nobody informed me that it would be conducted differently.
What-
I want to get this on the record.
Mr. Bennett Shaw, I am going. I don't know what you're.
I'm just showing you that it's all in our packet, that it is 3 minutes.
Okay. I'm going to go ahead and give 3 minutes for both sides to finish out what they're saying, to have that rebuttal, because it feels like there are things that you feel are important to leave on the record, as well as potentially anything from our city department. So any concerns from?
It's just that when you weren't here, I was counseled against doing that very thing.
Just note that if you allow a rebuttal at this time, we will need to allow a rebuttal for all parties at today's meetings. I believe we should just go ahead and do it. And
I'm sorry, what did you say?
it is, I believe it's at your discretion, but
I mean, I'm looking at our meeting procedures right here where it's all stated.
yes.
I mean, overall, we.
Page 4 of the agenda, of which there's a copy for everyone right there.
I don't know why the complainant expected 5 minutes at the start. That's not typically. I mean.
So I'm going to go ahead and give the rebuttal to all of the cases today, because usually people find that they have enough time, and I'd rather give enough time than to deal with people coming back and feeling like they weren't heard. So let's go ahead and set the 3 minutes and give both parties.
The respondent will be allowed to provide the rebuttal first, which is our standard.
Yeah.
Right. So you will get your opportunity, Mr. Bennett Shaw, but we're going to have to let the respondent go first. Do you have anything to?
I think the only issue that hasn't been addressed is the willful misconduct issue, and from our perspective, he has failed to demonstrate any evidence of willful failure. We admit that we made a good faith effort to record the meeting. We're not completely successful. And the notion that this was some type of willful violation to hold some sort of closed-door meeting, there's no factual basis for it. I rest on that.
Thank you. All right, reset the clock, please.
So you know the definition of 6734, willful failure is the failure to discharge any duty required by the Sunshine Ordinance. There are several willful failures in each of those first 3 causes of action. On page 39 in your packet, Mr. Nickens' response, dated July 13th, said that there were no board motion was made nor action taken on May 22nd. That is patently untrue. Just as DCA Cola's memo to you on page 16 in your packet that there was no actions taken. Again, that's untrue. My initial complaint noted on page 3 that Trustee Stansberry, who was conducting the May 22nd meeting, noted that this meeting is actually some action items. The meeting facilitator, Rick Funston, said he was operating under a principle called, quote unquote, management by objection, end quote, and if he didn't hear objections, he'd assume board members would agree to and adopt any given recommendation, whether it was a discussion-only agenda or an action agenda. On page 12 of your packet, Nickens' reply ignores the fact that I documented that Trustee Malia Cohen, as a trustee, not as a city supervisor, indicated that since the board had gathered at that May 22nd public meeting, that the board should not accept recommendation 1H, curtailing the retirement system's standard public comment on every agenda item, and Cohen stated that they would direct the retirement staff to not implement the proposed recommended change to public comment. Her comment was adopted on May 22nd as an affirmative action during what was later claimed to have been a discussion-only meeting. Therefore, action actually that was actually taken on May 22nd to reject that proposed recommendation had to have been willful, as many other points I would like to make about why there has been willful violations in this case.
Right, thank you. All right, hearing that, does anyone feel inclined to make a motion?
We've gathered up a few of these. Member Eldon. Member Eldon?
I'm struggling with this because if we're not in a position to say either way about willful violations, and we are still sorting through at least one of the 3 main complaints.
But we can still do 2 out of 3, and then that way we're that much further along.
I'm not sure the...
Well, what are you trying to get at, Member Eldon?
Well, the first one, which is 6714, video, audio recording, filming, and still photography. B is they should have been taking the recording, and the recording was not there, so that's a violation.
I would go with A also, if you're so inclined.
What's the distinction you're making between A and B for here?
I just thought they were so wrong. I was trying to give them 2, but as I'm rereading it now, presenting. Oh, that's you can bring your own. Never mind. So I think it's definitely B.
And for 6715.
Well, hang on. I'm sorry. I'm not done. I'm starting.
Are you making
C
a
is-
motion?
No, I'm doing it with you. We're doing this together.
I think you're supposed to do your own.
All right, go do your own.
For 67.15 public testimony, it does appear they did not provide that. So that appears for...
So your motion is to recommend violations of 67.14B and 67.15 and refer the 2 versions of the meeting agenda issue to the full task force without recommendation?
Let me just read this more.
Can I make a friendly amendment?
We don't have what the motion is quite yet. So
I was looking at 14C also.
Go ahead.
Because that just didn't seem like that it was fulfilled. So I could see it. If you were so inclined on your motion to add that to 67.14.
I didn't hear what she's adding.
she'd like to add 67.14C in addition to 67.14B.
May I ask, was this meeting held in City Hall?
Crap, it's only for City Hall?
Yes.
I'm going to strip that back out, sorry.
Thanks, Victor.
It was held off-site somewhere, if I recall.
So basically, for the second violation, they acknowledged that public comment was taken even though it wasn't put on the agenda. So let's see, what number was that again?
That's 67.15.
Yeah. So, anyway, can you read that back to me, what we have there?
We have so far 67.14B for failure to properly audio record the meeting, 67.15 for failure to list opportunity for public testimony on the agenda.
Right,
Public testimony was accepted, but it was not listed on the agenda.
right.
And then the pending one, where we are unsure how to proceed, is 67.7 regarding the two versions of the agenda.
Right, as well as any willful violations, as well as
And
any-
willful, 67.34.
So we have, and basically, the motion is for the first, to find the violations for the first two, and to defer the second 2 points to the full task force,
It's actually 1 and 3 and 2 and 4, but that's okay, yeah.
in the order he presented.
Oh, in the order he presented, yeah. I'll second that.
That's motion by Member Eldon, seconded by Chair Wolf. Public comment.
Any public comment on that? On the motion? Seeing none, go ahead and call the roll.
On the motion to refer those items with a recommendation or referral, Member Eldon.
Aye.
Eldon, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. This matter will be sent to the full task force. Parties will be notified when the matter is scheduled.
Great, thank you.
Before we can call the next items, I would suggest you consider asking them or the complainant if they are willing to combine or hear together their three complaints against the SFMTA, as there is consideration that it is a request for this. It is to the same department for the same information submitted to three different individuals at the SFMTA.
And Victor, can you speak to who these three individuals are, what their respective job
suggest-
titles are?
I would suggest you ask the parties. I'm not familiar with them personally.
All right, well, let's start with this. Who is here from the MTA? We just have one person representing. Great. And is Ms. Miles here? Great. Can you come up and we'll start to figure out whether we can combine this into one item or whether it needs to be three?
If we combine them, would we be giving more time?
It is what we're going to figure out at this point.
Thank you. I'm Mary Miles. I'm here for complaint numbers 17079, 17080, and 17081.
And our administrator has suggested that perhaps combining the three into one might be the best course of action. Do you have any concerns about bringing those into one item?
I would have no objection, provided that the force understands that that it is necessary to reach a resolution to each one, I guess. But as to the issues, they're similar enough that.
And how did you end up filing it as three complaints instead of one in the first place?
Well, I filed actually 4 complaints on July 17th. One to Mr. Salaberry, one to Mr. Tabajanda. I hope I'm not doing violence to his name, and the other to Mr. Montoya, and another to Ms. Wong. I received a response only to the request to Ms. Wong. These are all staff people of the agency, and I wanted their individual responses to particular items, records. That is, I wanted their records, their individual records as to these, the items requested.
Great. And how much time do you think you need to present your case for these 3 items?
I think it's quite simple.
So
I
if we
think you
give
mentioned 5 minutes as a combined item. I don't think it'll reach that far.
So 5 minutes, Victor? Can we do that?
May I suggest that we call these items to be heard together at the same time, and we can make allowances since there are, at discretion of the chair, to allow for 5 minutes as there are 3 items being heard simultaneously.
Great, that sounds great. Let's go ahead and do that.
Next on the agenda, item number 5, file number 17079, complaint filed by Mary Miles against Mike Salaberry, San Francisco SFMTA for allegedly violating Administrative Code, Section 67.25 by failing to respond to a immediate disclosure request. Item number 6, file number 17080, complaint filed by Mary Miles against Will Tabajanda, San Francisco Municipal Transportation Agency for allegedly violating Administrative Code, Sunshine Ordinance, Section 67.25. Item number 7, file number 17081, complaint filed by Mary Miles against Luis Montoya, San Francisco MTA for allegedly violating Administrative Code, Section 67.25 by failing to respond to an immediate disclosure request in a timely and/or complete manner. You have 5 minutes at this time.
Thank you, sir. Mary Miles, speaking to these complaints. First, this is relatively simple. It is a 67.21, 67.25 failure to provide any responses to the requests to Mr. Salaberry, Mr. Tabajanda, and Mr. Montoya. We received no response. I received no response to those particular requests. The underlying issue with which MTA, on which they've relied, is that they apparently believe that the agency does not need to respond to provide records of individual employees, and that is incorrect under both Sunshine and relevant case law under the Public Records Act. We refer in our 3-page brief, and we believe it's part of your packet, to the San Jose case that was decided by the California Supreme Court just a few months ago, and that pretty much really sealed this issue. And we believe perhaps MTA didn't hear about it. We think they must have their legal counsel. In any event, the site is San Jose versus Superior Court, 2017, 2 Cal 5, 608. In this case, the Supreme Court definitively states that an agency, any agency of the state, city, or any place in California must provide the individual records of its staff on request, even if those records are kept on a private device, a private computer or personal telephone or anything else. If they are requested, they must be provided. And again, I say it's a fairly cut and dried point, but it does need to be brought home, because what we have here is the agency is not denying that it didn't provide these records. It's denying that it has to provide these records. And it's quite clear that it does have to provide the records. If there's any questions?
We may have some questions for you, but our procedure has you speak uninterrupted, and then we'll hear from the respondent, and then we'll dig into questions.
If you'll allow me to check my notes.
Go for it.
Just to see if I forgot anything here.
I think you still got some time left. I can't see the clock from here.
Okay. In any event, I think I've also covered this in writing in our brief, so I'll just wait and see what happens here.
Thank you. All right, would the respondent please approach? And 5 minutes on the clock for the response, please. Great.
Hi, I'm Caroline Salaya, Manager of Public Records Request for the San Francisco Municipal Transportation Agency. And let's see, we did receive the 3 requests. The request was sent to 3 individual staff members, and I was copied, and so was the director of the agency. So upon receipt, I entered it into our database. It's an online database, and then I also sent Ms. Miles a receipt that the request had been received. It was the exact same request for documents, but just delivered to 3 different people, but it was for the same documents. So in essence, it was the same request. And so the process within our department is that we have about 6, 7 divisions within our agency, and within each one of those divisions we have a designee that's assigned to be the liaison to me, the main point of contact for the agency. I respond to all public records requests except for press. So I sent it to the division designee within our database. That person is responsible to send it out to all people that may have those documents. And of course, since the three people that were sent the request, they were definitely included in that search. And when they returned with the responsive documents, they were then put on a compact disc as per the requester's preference and mailed out to her, and a email was sent to her advising her that that had taken place. The documents were also made available online, but it was the same response for the same request, even though it was addressed to three different people. All the staff people involved and additional people, because I'm not always sure who may have documents. So numerous people were asked if they had the documents, and when they came back, there was only one person who said they had documents, Jennifer Wong. And within her documents, I double-checked them, there were some that a couple of other people involved named, I think Tabaganda Montoya, I think, were also copied on some of the emails that were responsive, but they didn't receive or send any, they were just copied. So Jennifer Wong's emails included all of the responsive documents.
Are you?
That pretty much sums it up. When Ms. Miles inquired as to why only one response had been sent, I let her know that it was the same response, so there was only one answer. And we do tell the staff people that when they get a public records request, they should send that to me, because I am the point person, the custodian of records for the agency. That way they don't have to worry about checking with other people. They can continue with their work. They just get it to me, and I make sure that it's handled and processed appropriately.
Great. Is that all you have?
Yep.
All right, awesome. A couple questions before you sit down. So the email that your department received came through at about 11 o'clock on Monday the 17th, and it was an immediate disclosure request. When was the response sent to Ms. Miles, letting her know that you had received the request, if nothing else?
It was sent out It's sent out the same day. The acknowledgement of receipt.
The acknowledgement of receipt was sent out the same day. And when were you able to put this stuff on the CD and send that out? What day was that?
The next day.
So it fell within the IDR time guidelines. Okay,
yes.
Great. It seems like you said that there were emails that Ms. Wong had written and copied, CC'd other people on. So wouldn't those other MTA employees technically be recipients of that email, even though it's the same email?
Right. But it was included in her emails. So therefore, staff felt that she had them. They didn't need to just make similar copies of the same thing, which is basically what it would have been.
So at this point, it's your position that the only documents she has not received are completely redundant except for the email header?
Pretty much, yes, exactly.
All right. Any other questions from my colleagues? And any questions for Ms. Miles? Ms. Miles, can you come up here, please? So you've now heard the MTA testify that all responsive documents are in your possession. Do you have any reason to think that may or may not be true?
Well, yes, I have every reason to believe both that they may or may not be true.
Well,
and
sure.
That even if they were true, that is beside the point and irrelevant to their duty and obligation under the law to provide responses to each and for each employee who was addressed in these IDRs.
So
those responses have yet to be received. For example, were they the same? How does Ms. Celaya on third-party removed hearsay claim she can speak for Mr. Salisbury, Mr. Tabajanda, or Mr. Montoya, and how does Ms. Wong claim to do so? I don't buy it,
Okay.
and I don't think you should either. San Jose case is very clear, very strong in enforcing the people's right, the broad right, to receive the documents of a government agency and not to allow the agency to hide behind just this kind of a supposition that it only needs to provide something that's been filtered through someone else.
I mean, I think you make a strong point there, Ms. Miles. Usually, when we are working with complainants, we're trying to both ensure that they get all the documents they were looking for, and as well as identify any possible violations that occurred. I understand the point you're making, that there should have been 4 responses to your 4 requests. How can we move forward beyond the actual responses around identifying what documents you may not have received that you have requested at this point in time?
Well, I haven't received any responses to the requests made to Mr. Salisbury, Mr. Tabajanda, and Mr. Montoya. They need to respond to each thing that was requested in the request and make their response to it. Not delegate that responsibility, which is also written in the Sunshine Ordinance, not delegate it to someone else. And that is the emphasis of the San Jose case, really. You can't hide behind a titled custodian. The records need to be provided. When they are addressed to a staff member, they need to be provided. The record is only as good as the source. That is my position. Not as good as something that's filtered through a delegated person who, sends the disc out.
So, with that in mind, I think I'm understanding where you're coming from. This, as I think you know, is a complaint committee, and then it'll go before the full task force.
Thank you.
Who needs to be at the full task force in order to provide the answers to the questions you're seeking? Because the Sunshine Law allows someone to be the representative of the department, but it sounds like you're making the argument that only these 4 people can actually speak to what records they may or may not be in possession of.
That is correct. They can speak to the response to the request. I have no quarrel with Ms. Salaya or whether she makes the response for this request to Mr. Salisbury or whoever. However, it needs to be clear that it's coming, that the source of the response is that employee.
All right, thank you. My colleague has another question.
I mean, the key point of Smith versus the City of San Jose, I thought, was the right to see emails and text messages about public affairs used on personal devices.
That it is one of the main points, but as generally stated in that decision, there's a very broad right stated there that the public has the right to an agency employee's records, regardless of where it's kept.
Well, sure. So I
it's
guess
kept in a file cabinet or kept on their iPad.
Certainly. I guess it sounds like what you're implying, but what we don't know for sure is that by getting responses directly from the 4 city employees you named, that could potentially reveal some of the communication that you are seeking that has not been provided to you. You don't know that it exists, but you would like, because you want them to respond to you directly, that is the legal route that you have to get that information, potentially.
Yes, and that should be a policy that's adopted by every city agency. They need, if a request is made of a specific employee's records, that those are the records that need to be provided. And whether they're kept in a private device or whether they're kept in a general file cabinet in the middle of MTA.
Ms. Leah, can you approach, please? So I'm trying to just figure out the best way to make everyone happy, and it seems like without hearing from Mr. Salaberry, Mr. Tabahanda, Mr. Montoya, I guess those are the three people we haven't heard from. Without hearing from them, the complainant is not assured that those documents don't exist and aren't in her possession. Is there some way to have a letter that's signed by those individuals to establish that they have looked through their personal files? I'm just looking for some way to satisfy the needs of the complainant through the respondent.
Yeah, I'm happy to go back to the staff people and ask them to confirm in writing that that is the case, that they did check their files and that they have no further responsive documents than those provided by Ms. Wong in response to the request.
Okay, thank you. Any questions before we go to rebuttals? All right, Ms. Lee, stay there. You're the first up for rebuttal if you have anything to add.
No, other than what you just suggested. And like I said, I'm happy to go to staff and ask them to put that in writing and provide it to Ms. Miles and to the committee.
Great, thank you. Ms. Miles, you have, Victor, how much time should we give?
3 minutes.
3 minutes?
Yes.
You have 3 minutes for your rebuttal.
May I suggest a question to the complainant? Is this acceptable? And if so, does she need to proceed further if she receive this certification from the individual employees? I'm just wondering.
Yeah, so before you jump into your closing statements, does where we're headed seem to be solving the problem, or?
No, it doesn't.
Okay.
I requested specific information from specific individuals employed by a city agency, and I didn't get it. That's
Okay,
a violation
let's,
of law.
Ms. Miles, we're going to have to start the clock.
Okay.
Ready?
That's fine, but that's not acceptable to get some statement. Oh, Ms. Wong has answered for us. Well, no. For each of these people, they need to provide a response to my IDR request. Of course, they're late, very late in doing so. That itself is a violation, but it's also a basic fundamental violation to not provide a response to each of those requests from each of those employees that says, I have this, and this is what I am providing. If it's the same, that's for me to discover. If it's not the same, then fine. Then we've discovered something else. But that's the whole purpose, isn't it, of the Sunshine and Public Records Act, is to enable people to discover public records. So that's all I've really asked for. Seems cut and dried.
Are you?
Well, yeah, if there's any other question, I'm happy to answer it.
So we have the little rebuttal period that's sort of an uninterrupted time for you to talk. I think my colleague does have a question for you, however.
I mean, the ordinance does provide for custodians of public records, these agencies, to help manage the process of responding based on individuals. I mean, that seems relevant here. I'm trying to, the custodian of public records does have the means to respond, right? I mean, you don't really address that. So.
She may respond, but each employee is its own custodian under Sunshine and under the law, because anyone who has custody of those records in any fashion, that person is a custodian of public records. I mean, that's part of Sunshine. But I'm not sure why we're digressing here, because this seems like a simple matter where somebody has requested so-and-so's public records, and so-and-so is an employee of an agency, and that person hasn't received a response or any responsive records.
Thank you.
So that's what needs to be done, and I also would say a violation should be found because that hasn't been done.
Great. Thank you. We'll be preparing a recommendation, and then we'll make a motion, and then the full task force will be the one actually making any decisions on the matter. Just as a prologue, I think that part of the issue here is that there's sort of a way things are usually done with departments responding to requests, and I think that the point that you're making is a compelling one, but it's outside of what we normally deal with in terms of arguments. So I think there's a little bit of back and forth that's going to need to happen as we sort of put our heads together on this. So just go ahead and have a seat.
Will I have a further opportunity to speak?
You will have a further opportunity to speak at the hearing itself that'll come up, and you always can submit anything in writing to be added to the packet for that. So you have plenty of times to still get your voice heard before any decisions are made, and I think we have enough to come up with what our recommendation is going to be. It's just we just are going to need to go back and forth a couple of times to figure out where we end up.
Okay, I just have a very deep disagreement with you if you believe that I'm supposed to believe, or that any member of the public's supposed to believe, that a third party can say, these are all the records, even though I'm not responding to each individual request that you've made.
I'm not saying that is or isn't the case, Ms. Miles. All I'm saying is that we are empowered to make a recommendation as to whether or not we feel there was a violation. Then the full task force essentially does a de novo review of the case, and we just sort of help provide additional information to make the process work faster. So there's still a de novo review with the full task force at the upcoming meeting.
Thank you.
You're welcome. All right. Who's got thoughts?
I guess I have a question for Victor. Am I missing something here? I mean, for years now, we've had...
That is up to you to make that interpretation.
Let me interpret this. For years now, let me state this to my colleagues, we've had many, many departments come through here with complaints for staff, and we've had the public records person. So I'm representing. So, and it always comes down to, did you get the records you wanted? Did you get the information you wanted? Was anything withheld? This seems like a bit of a twist. Am I
So the
missing something here?
Sunshine Law says that only the public records, custodian records, or whoever's in charge is supposed to go to the meeting. In terms of actually who has to respond to the request, not the complaint, but the request, it's not nearly so cut and dry. The argument that I've made the same argument that Ms. Miles made around trying to do public records requests to individual police officers in the past, and gotten nowhere, but that was prior to my service on the task force, actually. But so I understand the argument that she's putting forward. It just is very different from the way that business as usual is typically conducted, and that leaves me... My inclination is to acknowledge that there isn't a need and a valid argument here, but to move it forward without a recommendation, because we don't have our own legal advisor here to weigh in on this. I've had the same thoughts, but I don't have the legal wherewithal to know whether my thoughts have merit. And on the one hand, you can look at it as a request was made, a response was from the department, came back within 24 hours. The response did not come back from each of the people that received a request, but we've never, in my tenure, looked at it from that framework before.
Well, we have to be careful here. if we say there's a difference between no violation or we're stumped. You know, if we
I
say
said no
violation-
recommendation,
okay,
not no
recommendation.
violation.
That's sort of.
I mean, there's
we're stumped.
the issue here is a pretty profound one for how we have operated.
Yeah.
And I definitely don't want to make a recommendation without getting more clarity from the city attorney and the other members of the task force. So, I mean,
Is
certainly
there a motion to find jurisdiction and no recommendation?
I will make that motion.
The motion is to find jurisdiction, determine that the records requested are public records, and to refer the matter to the full task force with no recommendation.
Okay.
That motion is made by Member Eldon. Is there a second?
Oh, second, sorry.
Public comment?
I jumped the gun.
Seeing no public comment, go ahead and call the roll.
On that motion, Member Fisher.
Aye.
Fisher, aye. Member Eldon.
Aye.
Eldon, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
And before we close that, what is the best way for you to synthesize what transpired and get it to our legal?
I will provide a summary and provide him the audio recording and ask him to. I will ask DCA COLA to be prepared to respond to this question.
Great. And if there comes to prioritizing, I think this is kind of the top priority because it's so far outside of the way we've normally had to deal with things.
Yes.
Great.
It's not clearly addressed in the ordinance.
And I'd like just to let the parties know, it's my intention to schedule this before the full task force to be heard as it was today concurrently with each other.
Great.
Or to
Thank
be
you.
called together.
All right, go ahead and call the next item, please.
Next on the agenda, item number 8, file number 17097, complaint filed by Mark Bruno against the Planning Department, Board of Appeals, and the Department of Building Inspection for allegedly violating Administrative Code Section 67.21 and 67.25 by failing to respond to a public records request in a timely and/or complete manner. There is a slight twist to this, as there are 3 respondents named, and they will probably all be responding on their own behalf, and I assume they would all be allowed their own 3-minute time period.
That sounds fine
And would you
to
like
me.
to give additional time to Mr. Bruno so that, as there are 3 different complainants,
I don't think there's.
Complainants or?
I don't think there's
I
an
mean,
argument.
respondent.
Yes.
I don't think there's an argument for him to get additional time in the first 3 minutes, but arguably he should get 3 rebuttals. Because the respondent, we have 3 respondents that'll get 3 rebuttals, and then he has to respond to each of those 3 rebuttals.
I'm happy with that, thank you. Yeah,
okay,
that's possible.
I believe that's acceptable.
Sure.
All right, let's do that.
Give me a moment.
Oh, I'm sorry, should I start?
You've
yes.
got 3
Okay,
minutes,
I didn't
sir.
realize that. Sorry, my name is Mark Bruno, and I want to thank Chairperson Wolf and Member Fisher and Member Eldon for hearing all these complaints today about something that's so significant to our lives as citizens. I'm not an attorney, and I noticed in reading the response from the city attorney as well as from the Board of Appeals, so the Board of Appeals is here as one of the respondents, that it seems you should be an attorney to be able to ask for information from the city. Of course, Sunshine Ordinance is meant for the rest of us, for people who, like me, don't regularly appear before city agencies or boards or the planning department or building department, the other respondents, but simply want a plan. A plan here in this case means a building plan, like the plan that was made to create this building. The plan in this case that is being proposed to create a garage in the little neighborhood where I live and have lived for 30 years, where I run a homeless program and have done for 17 years, where I ran for supervisor, where I care about the people, and where 15 people, my neighbors, came before the Board of Appeals between July 12th and other hearings between July 12th and September 13th, when the matter was finally decided by the board, when all 15 of us came at various times to appear to say, we don't want this garage. How many people from the neighborhood came to say, oh no, we really think this would be a great idea? 0 came. And yet the Board of Appeals decided in favor of the owners of this house that want to build a garage. But all we're here today to ask for is why, in this matter that took from early this year, because that was when the plans were first submitted to the building department and planning, the plans were first submitted by the owner of the house, why do we still not have an offer until last week from planning, or rather from the building department? You can see it here. They'll say, oh, well, it was actually the week before. The point is, and I realize there's not much time left, let's just look at 2 dates. Again, I said it quickly, but I'll repeat it. On the 13th of September, a decision was made. You can see it's actually dated the 26th day. Oh, you don't have a way to show it here. Well, anyway, it says the 26th day, and it's in your package. And that 26th date of September is the affidavit confirming that the Board of Appeals made a decision on the 13th. Well, why is it that 16 days later or so, I'm being offered the plans that we've been asking for since all year long? And there's proof here, as well as in your package, which I'm happy to offer, that shows it's a computer system by the planning department and by building. It shows you when plans arrive. And since there's not much time left, I'll just show you quickly this very colorful, document, which is the computer system that shows you that Elish Tuffy, the representative of the planning department on this project, received these plans, a revision of the plans, in January of this year. But we're being offered them now. It's quite unfair, and it prevented us from being involved in the project. Thank you for your time.
Right, thank you. All right, let's start the, what?
If I show you a picture of the building.
Okay, let's start with the respondents. I guess we'll go Planning Department, Department of Building Inspection, and then Board of Appeals last, because that's probably the order that this went through the... Hi.
Hi, Christine Silva, planning staff. This is in response to file number 17097, filed by Mark Bruno against the Planning Department, Board of Appeals, and Department of Building Inspection as related to a proposed development project at 20 Nobles Alley. Our records indicate that the complainant submitted 4 total records requests to staff. The first request was submitted via email on August 8th, 2017, requesting documents related to the North Beach survey. Later that day, planning staff Elish Tuffy responded to the email attaching the responsive records. A second request was received via email on September 5th, requesting plans and environmental review documents, to which Elish Tuffy of staff responded that same day, attaching a PDF set of plans, while also indicating that the environmental review had yet to occur and therefore did not have those records. The third and fourth requests were both received on September 8th in separate emails, one which again requested the environmental review documents, and another that requested the Planning Code Section 311-312 notice for the project. On September 11th, planning staff Monica Hudgens emailed the complainant the completed environmental review documents in response to that third request. And then on September 8th, Planning Zoning Administrator Scott Sanchez responded to the fourth request, indicating that Section 311-312 notice was not required for the project and therefore did not exist. Lastly, on September 18th, planning staff Elish Tuffy emailed the complainant additional supporting documents, the majority of which were duplicative of records already produced to the complainant, all of which supported the environmental review for the project. Due to the size of the files, these documents were sent via a download link. At this time, all responsive records have been produced to the complainant. The complainant alleges that that planning is in violation of Admin Code Section 67.21 and 67.25 by failing to satisfy immediate disclosure requests in a timely and/or complete manner. That is incorrect. With respect to Admin Code Section 67.21b, for all 4 records requests, planning staff responded in a timely manner, either responding the same day of the request, the same day the request was received, or within a few days of receipt. None of the responses exceeded the 10-day time frame as set forth in the code. In addition, none of the 4 requests were submitted as immediate disclosure requests, as defined by Admin Code Section 67.25a, in that none of the requests included the words immediate disclosure request placed across the top of the request or in the subject line. The requests our office received were general records requests. Lastly, to clarify, in the complainant's submittal, he indicated that a request date of July 2nd, 2017 for the planning department. However, staff has no record of any requests received on this date. Instead, our records indicate requests received between August 8th and September 8th, as previously explained. For the foregoing reasons, we respectfully request that you dismiss this complaint and find us in compliance with the code. And I also have copies of all 4 requests and then all 4 responses if you want to see that. Thank you.
Great. If you could provide those to Victor to include in our packet for the following meeting. All right. And is someone here from DBI here to respond as well?
Dan Larry, Department of Building Inspection.
Could you repeat that? It was cut off. Your name?
My name is Dan Larry, Department of Building Inspection.
Whenever you're ready, sir.
Okay. At the request of Mr. Bruno has communicated with our department and inspection services and with our communication officer, William Strong, requesting the documents. He entered in an email that he would like to make those documents public. We responded to Mr. Bruno in phone calls and in emails stating that we can't reproduce those permits that he requested, that he's allowed to view them. What originally happened was that planning had those plans in for a long time, and then after the planning made the decision to disapprove those plans, they were routed back to building. A request letter was sent in 7/13 to Ann Hugh, plan reviewer, to cancel that permit, and the permit was canceled. Okay, when a permit is canceled, it went down to the Central Permit Bureau, and usually they're destroyed after they're canceled. Upon Mr. Bruno's request, our staff looked for those permits and we were able to find those plans. I contacted Mr. Bruno on Friday, October 6th, and told him that would look for those plans. We did locate those plans. They're normally destroyed, but we did locate those plans, and they said they're available for view. But what the state law for plans is that we can't just publish them for the public. They have to have the permission of the architect and the owner. So I told them they're allowed to view, that I have the plans in my office, that he is allowed to review anytime he wants, but we can't publish it for him. Okay.
Is that everything?
That's it.
Great, thank you. All right, and last but not least, we have the Board of Appeals.
Good evening, Chair Wolf, members of the committee. I'm Cynthia Goldstein. I'm the Executive Director of the Board of Appeals. I don't believe that Mr. Bruno has actually alleged any violation by the Board of Appeals. If you look in your papers, he has acknowledged the fact that we timely informed him that we did not have the plans that he was seeking. We're not here to hear the appeal of the garage permit again. That's something that the Board of Appeals has decided. We were aware that Mr. Bruno wanted to see the building plans for the proposed garage, but he knew that we did not have those plans, and he knew this because on July 12th, at a Board of Appeals meeting, the board continued that case in order to get copies of the plans. The board did not want to make a decision without those plans before it. He attended that meeting, and he has evidence of that in the submittals. He asked us by email for a copy of the plans, and on the 18th of July, actually what he asked on the 18th of July was what plans had been submitted and where were they located in the packet of materials. So he actually didn't submit a public records request. He had a request for information, but we treated that broadly as if it was a public information request or public records request, and responded to it on the 20th of July by saying that we did not have those plans and that he might look to the Department of Building Inspection for them. In the interim, on the 18th of July, he attended a meeting at which he himself stated that he discovered that the complete record of the project, specifically the project plans, were not submitted to the Board of Appeals. So there was nothing that we could do to provide him with documents that we did not possess. We did not refuse to provide the plans to him. We did not fail to search fully for those plans, and we responded to him in a timely manner. I know that he complains that we should have had the plans in our files, but that is not something that I believe this body has jurisdiction over. What documents are submitted to the Board of Appeals are actually not within our control, and what documents the Board of Appeals members consider when deciding an appeal, I respectively say are not within your jurisdiction. Mr. Bruno is mistaken that there is a regulation that the Board of Appeals has control over that requires such plans be submitted. There is a provision in the Business and Tax Regulations Code, and it asks that departments provide certain documents to the board when an appeal is filed on a determination that they make. But the board is not responsible for enforcing this provision, and as I said, I respectfully suggest that neither is the Sunshine Ordinance Task Force. So I believe there's no evidence in the record to support any violation of the Sunshine Ordinance by the Board of Appeals, and I do ask that you dismiss this complaint against us.
Great. Thank you.
Thank you.
All right, Mr. Bruno, I've got a few quick questions for you. So,
Sure.
So we have three different agencies, three different stories. I just want to try to clean this up. So we're going to work backwards. So
Okay.
the Board of Appeals, Ms. Goldstein has said that she's under the impression that you have not alleged any violation against the Board of Appeals. Is that accurate?
May I point out that under 67.21, which is the section of the Sunshine Ordinance where I'm bringing this action, it states right here under C, a custodian of a public record, in this case, the Board of Appeals, the executive director is Cynthia Goldstone, who just spoke, shall assist a requester in identifying the existence, form, and nature of any records of information maintained by, available to, or in custody of the custodian. Because the Board of Appeals is the one place where the public is permitted to comment on these plans, which you've already heard from the building department, are not generally considered available to the public. In fact, it's written down by Mr. Strawn that they're copyrighted. Because of that, this is the only opportunity for a neighborhood to comment on a building project with a complete record. Cynthia Goldstone, who just spoke, just commented that this is just a bypassage of the law, that it might be true that the Taxation and Business Code requires some sort of record. It's not might be true. It's here, written in 1982, and it's a submitted pamphlet that's handed out by the Board of Appeals to those of us who are not expert, who do not regularly appear there, and who are not lawyers. Her own board hands this out, and what it says.
Sir.
Yes.
I'm gonna ask you 3 yes or no questions.
Please.
And I want a yes or no answer.
Okay,
to each
please.
of them. Do you think that the Board of Appeals may have violated Section 67 of the code?
Yes, they did.
Great. Do you believe that the Planning Department may have violated Section 67 of the code?
Of course.
Do you believe that the Department of Building Inspections may have violated Section 67?
Yes.
Okay, so you have claims against all 3 agencies. That's what I wanted to sort of, because if we could parse one of these out, we'd clean this up and move forward. But you have claims against all 3, and I hear where you're coming from on at least some of those.
I want to point out also one thing, which is the Board of Appeals and they'll confirm this, used to be called the Board of Permit Appeals. All of us who live in the city know that in 1999, it was changed to consider other permits. But even to this day, approximately 85% of what's heard are building permits. There's a symbiotic relationship between these two departments, building and planning, and the Board of Appeals. This is the one opportunity, again, the Board of Appeals, when plans can be seen. And the point of the planning department that they gave us plans is a absolute untruth, perhaps inadvertent on the part of the department. The plans we requested are the original plans by the applicant, plans that were submitted to the department, meaning the planning department, back in 2016. The plans they gave us were revised plans after hearing what the Board of Appeals wanted them to do. So it was a way to cut out the public from the process.
So for better or worse,
yes.
The details of how these different sort of process of becoming a way to wear the plans seems like it's not necessarily in our purview. What's in our purview is that when you requested documents, whether or not you received them, whether or not the departments were legally obliged to provide them for you, whether they responded to your requests. And that's sort of what I'm trying to parse out. But I'm going to go ahead and take a step back and see if my colleagues have any questions. And I'm going to do some quick looking at this documents. Do either of my colleagues have any questions?
No.
All right. So it seems like not yet. All right, so it seems like nobody has any questions at the moment. Let's walk through this piece by piece. So I think I understand that. Let me summarize, and you can say warm, cold,
okay,
or like you're out
I'm
to
sorry
lunch.
There's so much information. But
it's fine. It's fine. I'm just trying to make a complicated thing as quick and seamless as we can without losing anything at the same time. So it sounds like what's happening with the Board of Appeals is that the plans that that in your mind they should have had in their possession
on July 12th,
and that the actual members of the Board of Appeals had said they wanted these documents, but they never got them, and so you're asking for documents the Board of Appeals never got.
Not now, we're not asking for them. We were asking for them at that meeting on the 12th. We said, and we even hired an architect to ask as well, but how can you proceed, we said to the Board of Appeals, when your own requirement says right here, upon receipt of notice of an appeal, this is what's handed out to the public, it shall be the duty of the department, board, commission, or person from whose decision the appeal is taken, meaning these guys, the building department and the planning, it shall be their duty to submit all affidavits, exhibits, letters, plans, maps, other documents used upon the hearing before such department. So
right. So I hear you. I hear you. Unfortunately, we are not the appeals to the Board of Appeals.
Right.
And we also really. We're not here to verify that they followed their policy either.
But under your own sunshine ordinance, under 67.9, which I read today for the first time, admittedly, because I was up helping my mom with the fire. She's in a place, Grass Valley, where there are fires, and I stayed there until yesterday. But under 67.9, it says very clearly, the Sunshine Ordinance declares, records which are subject to disclosure, which I claim these are, and which are intended for distribution to a policy board or to a review board, which this Board of Appeals is, shall be made available for public inspection and copying upon request prior to the commencement of such meeting, whether or not actually distributed or received by that body at the time of the request. In other words, it doesn't matter. What the Sunshine Ordinance is saying is, our whole point in being here, the Sunshine Ordinance and Task Force says, is to allow normal people to see their government work and maybe to participate if they choose to. And in that, it's a complicated thing to be able to do because there's a lot of records around. So we're saying that if you're not responsible, somebody must be. Cynthia has told us, well, we're not responsible for making sure that building and planning has handed in the plans. After all, we're just the neutral Board of Appeals. But if they're not responsible, then you have to be, because there's no other way for the public to make sure that the process, that the glue holding it together works. And again, I'll point out one last thing, and then I apologize for speaking over you, but it says right here on the very first page of why the Sunshine Ordinance exists, new approaches to government constantly offer public officials additional ways to hide the making of public policy from the public. That is what has occurred here. As government evolves, so must the laws, these laws, designed to ensure that the process remains visible. If
Okay.
the pieces don't fit exactly, they fit close enough to justify taking it to the full task board.
Oh, this will go to the full task force no matter what, sir. You
Okay.
don't need to worry about it going to the full
Thank you.
task force.
I appreciate that. Thank you.
Everything goes to the full task force. It's our job to sift through, make sense of it, to sort of take the file.
Sure.
You know, have a case agent. They take all the documents. They're like, oh, you got these like papers that are blank. We're just sort of cleaning up the file. That's what
Right.
our job today is. And so let me just rewind something back
Sure,
to you. Which
please.
it sounds like you're saying that you feel that the Board of Appeals violated Section 67.9.
Exactly.
Just
Yeah,
let
sorry.
me talk and then you
Okay,
can
okay,
respond. That you feel that they violated Section 67.9 because they neglected to obtain documents that they never had in the first place and then failed to give you documents that they neglected to obtain.
And that was available
Is
to
yes
them
or
under
no?
your ordinance. That was available to them, not only because it states under your ordinance that the custodian is responsible for those documents available to her, but because if you look in real life, there's a symbiotic relationship between this board and the building department.
I understand
Yeah.
all of these pieces,
Yeah.
but I am very limited in what we can do as a task force. So let me just repeat this back to you, and I want a yes or no. You feel that the Board of Appeals violated Section 67.9 because they failed to obtain documents that they were obligated to provide to you, but they neglected to obtain them, and they were critical for the Board of Appeals making their decision. Is that
Exactly, yes. You said
Okay.
it very well. Thank you.
we have never in my tenure dealt with the issue of documents that were not in their possession having should have been in their possession, to the best of my knowledge. So this has been a day of interesting new nuggets.
It's a new world. What can I say? It's true.
So I think that I'm not sure how my colleagues feel, but I think we're going to have to put that one on the side burner and deal with that with a lawyer, because that's like either lawyers or like go back to the Summer of Love and solve it that way. But it's a
That's
head
fine.
trip to wrap your mind
I'm for
around.
the Summer of Love. I'm in favor of that.
Let's go to the DBI now. Let's just go step by step here. So the Department of Building Inspectors received a request for documents from you, and their response was, normally we throw these documents out, but let's see if we still have them. Then they said, we have them, but we're legally obligated to not allow you to have them in your possession, but you can come over and take a look. Is that an adequate summary of what happened with DBI?
I don't know what they're saying. They've said so many things to deliberately or inadvertently avoid giving us. They're not documents, remember. It's just a plan, like a landscape, like a
Mr.
blueprint.
Bruno, can you just step aside for one quick
Yeah, sure.
second?
Yeah.
And can someone from the DBI say whether my summary was accurate?
Hi, William Strawn. I'm the Communications Director. Yes, what you just said is reasonably correct. I would just point out that one of the frustrations I think Mr. Bruno is struggling with here is that plans are considered copyrighted documents, and by state law, there is a protocol that the building department has to follow for anybody who wants to receive a copy of them. In this particular case, there's a further spanner in the works in that the plans that he wanted to have published and copies made of were actually canceled in May. So we have a situation here, legally speaking, where these plans never got issued. And as far as the building department is concerned, and I suspect the planning department and the Board of Permit Appeals, they're not real plans because they were canceled. They were never issued. So the reason we couldn't find them when Mr. Bruno came to us, I believe in July, and we spent some time searching for these plans, was that this cancellation had happened 2 months before, and as Deputy Director Lowry mentioned in his statement, they had been sent to the recycling bin. And normally, they would have been shredded and recycled because they had never been issued. However, when Mr. Bruno said he still felt he should have the opportunity to see them, and actually we make it a policy. We're happy to have people come in and view plans as long as they understand they may not make copies, they may not take photographs unless they get the owner's permission and unless they also have the architect of records permission. There is a 30-day process that our records department walks people through very methodically. It's systematically set up. A lot of people go through it. As far as I know, Mr. Bruno did not try to obtain either of those permissions to obtain copies of those plans. He wouldn't have been successful since they had been canceled at any rate by that time.
All right, that's all mostly helpful. And I realize that, Mr. Bruno, I realize that what you're hoping for is not important to this, but I need to do this just to make sense of things. You were opposed to the garage coming? Is that?
Yes, me
okay.
And 15 other people.
That I don't care about. I just trying to understand.
Yes.
So it's not your garage.
No.
You're stopping the garage. If I can speak.
I just want to know what's.
That's fine. We'll let that happen. Sir from DBI, I didn't catch your name.
William Strawn.
I'm sorry, I'm William Strawn, yes.
Yeah, so this was the plan, the permit to create this garage. That permit was withdrawn.
It was not the permit. We're talking about the plans, not
okay,
the permit.
The plans were withdrawn for the garage, but now the garage is moving forward. Are those the same plans that you received, or are there new plans? How does this work? I've never built anything in my life.
I'll let Deputy Director Lowry speak.
Great.
Commissioners, Deputy Director Dan Lowry. It was a permit application for relocation of a garage door. I guess the original complaint on the garage was that these garages were put in the 90s. This was a permit to comply with the notice of violation to relocate the garage. This permit went through planning. He took my documents there, but planning disapproved that after keeping that for a while there. There's a comment from planning that they disapproved the plans, and it was never reviewed by our plan review staff because planning already disapproved it. When it came back to us, there was a request letter for cancellation. It was canceled per the request letter. I think it was in May 8th. So when planning disapproved those plans, we didn't even have access to the plans, even as DBI, because they were routed at planning.
Right.
And so when they came back to us with a cancellation letter, we canceled the permit. Now, the problem with the canceled permit is that if it was an issued permit, it would go to records. It get microfilm. It has access. But with a cancellation permit, it goes to our Central Permit Bureau to be disposed of because it was never issued.
Right. It's like canceled. It never happened.
Yeah.
But it sounds like the garage is still moving forward. It seems like Mr. Bruno is here in many ways around. He's upset about this garage moving forward. He's not just upset about the process, it seems. So I'm trying to understand where the plans for the garage have been gone to central permitting and been destroyed. It seems like the garage is still moving forward. How does this work?
Okay, they normally do get destroyed, but what we did is that we looked for those plans at Central Procurement. We did find them. So upon finding those plans, we contacted Mr. Bruno right away that the plans are still available, that he's allowed to view them, but under the viewing rights, we can't just print them and give them.
Right. No, I understand that. I'm more trying to understand what's actually going on here, because I was following it until we started talking about how these plans have been disapproved. Planning didn't approve this. So it seems like.
May I comment? Yes.
Yeah, someone help me with the narrative here.
We know each other as friends as well. And he knows, because we both know somebody who recently passed away in the neighborhood, my neighborhood, Lorenzo Petroni, that I am not somebody who cares more about a garage than process. I am somebody who cares. I would rather have 5 garages than a bad process, because when we're all dead, we are going to leave the people after us a process that has to be fair, transparent, and in accordance with the Sunshine Ordinance. So to answer your question, what happens happened is the people who own the property appealed the denial by planning. They said, we don't agree with the city. The city denied the project. In other words, the city said, you cannot build this garage for very good policy reasons. But the owners of the property said, we want to appeal it to the Board of Appeals. It was at that point when they appealed it that under the law, they are required, just like going into a court, to hand in a complete record so that we all of us, you, me, Aaron Peskin, Lorenzo Petroni, had he been, we could all see what their project was, but we never had that opportunity. So it's a major public policy issue here when, by denying the plans, you've denied the right of the neighborhood to participate in the property owner's appeal of a decision already made by planning.
Got it. So my breakdown of confusion is that I didn't realize that it was denied, and then they were appealing the denial.
That's what happened.
Because in my neighborhood, what always happens is they approve something, and then the neighbors go to the Board of Appeals to stop it. So the inverse didn't wrap my
Let me
around my
add
head.
one more sentence here that's important. It was denied for a very specific reason by Elise Tuffy. She has a 3-page document, which you have, and which Board of Appeals got from planning. It's the denial letter. It's only a letter of denial that was written May 8th and issued to the property owners. And it says, one of the main reasons we're doing this is because David Chu and the Board of Supervisors unanimously in 2010 passed for North Beach because they wanted to preserve housing. The refusal to have additional garages and alleyways because they were being used as an incentive to make TICs. So it is a public policy issue. It's not just about a game.
I understand that, and I just need to
You got it right.
I just need to drive home the point that, like, we are solely focused on sunshine and public documents issues. It sounds like you have a very compelling case to appeal the Board of Appeals to the Superior Court or something.
Of what's going on.
I appreciate the context, but it's one of those things where there's so many different things spinning around in the solar system, and rather than increasing the planets and the satellites, I'm just trying to reduce it down as much as possible.
Well, it's been stipulated by the city attorney and by Cynthia. It's been stipulated that I asked for the plans. I personally, she comments in her letter, and she'll have a chance to refute this if it's not true, but it says in her letter to you, Mr. Bruno, me, appeared on July 12th and asked for the plans. Not the plans that didn't exist yet, but the plans that were canceled. I asked for them because it was the only way to know what was being proposed, and I never received them. So it's a very simple matter. So we asked for plans and never got them from anybody.
So you asked for plans from the Board of Appeals.
At the Board of
they didn't have the plans in the first place. You asked, let me continue.
Yes,
please. You asked for plans from DBI. DBI said you could look at them, but we can't turn them over.
They said nothing. They didn't say that till 4 days ago. At the Board of Appeals hearing on July 12th, the representative from DBI was sitting there, Bernie Curran. The representative from the planning department, Scott Sanchez, was sitting there. I asked the Board of Appeals for the plans. It seemed that they weren't there. And I then turned to them, and it's all as a matter of record on video, and I said, Mr. Sanchez, do you have the plans, meaning the planning department? Do you?
Okay, great.
Nobody had the plans.
All right, so let's
been offered the plans until 4 days ago.
I heard you. I have a sense of what you guys are going to say, but I'm just going to try to piece these parts together. So I have a sense of DBI. Let me move on to the planning department. Your complaint about planning department is basically that you requested documents on 4 occasions.
Right here. They got them on July. It tells
we need to speak in the microphone.
Oh, yeah, okay. So it shows you if you, I don't know, can you guys see the same thing that everybody?
We can see it,
sure. Yeah. So you'll see that it was explained, because this is important, that when you build a garage, it's called a major project. Mr. Strawn can confirm that. When we first met, he said, that was one of the first things he said is, no, it's a major project. If you look up here at item, which is Form 3, that means that when a person asks to build a garage, because it affects a lot of people's lives, including housing, that 3 means that you have to do it with plans. The plans are part of the application.
Okay, sir, none of that I understand how the process may have broke down. None of those processes actually intersect with our jurisdiction. What happened was you requested documents to the planning department on 4 occasions, correct?
At least on 4 occasions.
At least
yeah.
on 4 occasions. Okay, well, we can go through and figure out if there's any additional ones. The planning department contends that they responded back within either that day or a few days on each instance.
I don't contest their timing. I've never asked for an immediate record document request. I don't know why that was added to this complaint. I've never.
So your issue is that they had documents in their possession that they didn't give you?
Within the 10-day maximum. It's a 10-day, without the IDR, it's 10 days, according to your law, right? According to the Sunshine Ordinance, they have 10 days. But what actually happened here, instead of 10 days, was 158 days. That's when I got the plans, 158 days after the original request on May 8th.
All right. Mr. Bruno, can you sit down for just a quick
Please.
second?
Sure.
Would the representative from the planning department come up, please? So it sounds like Mr. Bruno sent numerous requests for various documents over a period of time. One of the things he was looking for was the plans, which he didn't receive, according to him, for 158 days after requesting them. Is that true? And if so, why did that transpire that way?
I do not believe that's true. However, if he has evidence where he did request them 150 plus days ago, I'm happy to review that. The records that we have are 4 requests, all in between August 8th and September 8th of this year. They varied. The one request where he's asking for plans, which were the plan revisions, was on September 5th, and we provided those plan revisions because we did have a PDF of that set also on September 5th.
Okay.
So to my knowledge, we have not received a request where he explicitly asked for that first set of plans, and where we did not respond.
All right, great. Thank you. Mr. Bruno?
Well, she pointed out something very important.
I'm sorry, Mr. Bruno, stop for a second. I
Yeah.
need to talk to my administrator.
We have this during rebuttals? We're getting into rebuttals during questioning.
Well, I'm trying to understand.
I understand. I'm just.
Yeah.
Well, the answer by planning was very accurate. The request was for the original plans, as she just pointed out. So it's easy to confuse what eventually.
What day was that request made?
Well, that was originally made to Mauricio Hernandez in the building department in writing, which is part of your packet, on or about the same day that the planning department denied the proposal. I then wrote to him and I said, "What happens now? Where are the plans? I want to see what's being proposed." That was May 8th.
Okay. So, Mr. Bruno, I don't know. We're going to move to rebuttals in just a second.
Okay.
I don't know how to simplify this record so that it goes before our full task force in the future and is able to easily dissolve it. Obviously, our administrator will help to work to get the file in order, but what I'd like you to do is to really identify basically every time you request a document, the city has 10 days to respond. If the city didn't respond in 10 days, I want you to make a note of that. If the city did respond in 10 days and you didn't get what you wanted, see if you followed up. But what I want to see is all the actual clear-cut violations, because there's we don't live in a world of black and white, but all I see right now is gray, and I can't parse that. So what we're going to do is we're going to go ahead and have rebuttals from each of the 3 agencies. They're each going to get to talk for 3 minutes, and then you'll get an opportunity to respond to everything that's been said.
Thank you very much. I appreciate that.
All right, let's go, I guess, in reverse order than we started. So we'll start with the Board of Appeals, and then DBI, then planning.
Thank you for this additional opportunity to speak. Again, Cynthia Goldstein, Executive Director of the Board of Appeals. I do want to make one thing clear. I'm not sure, Chair Wolf, if you fully understand that there are 2 sets of plans that we're talking about. So the original set of plans that were canceled and almost destroyed, and then there was a second set of plans, I believe this is correct, a second set of plans that were prepared and actually submitted to the board, upon which the board made its decision. So those were the plans that the representative from the Planning Commission said were provided, or that were provided to Mr. Bruno on the, I think she said the 5th of September, and we posted them on our website on the 8th of September. So those were available, 2 different things, okay?
2 different sets of plans for the same thing, like an outdated plans and then the revised plans? Is that what we're talking about?
I don't know if they were, I believe either they were revised or because the other plans were unavailable to the project sponsor, they created new plans for the board. The board specifically wanted to see some plans before they made a decision.
But we're talking about parallel documents to build something vaguely similar.
I believe so. I haven't
Great.
seen the original plan, so I couldn't say for
Sure,
sure.
I'm
but
just
that
trying
would
to-
be my understanding, yes.
Great, thank you.
So I just wanted you to be aware that there were a set of plans that were before the board when they made their decision, and that they had been made available to Mr. Bruno before the board made a decision, and that Mr. Bruno had an opportunity to speak about those plans at a public meeting during public comment on that item. Okay. My question to you is, what more should the Board of Appeals have done? I don't believe that there's anything more that we should have done under the Sunshine Ordinance to satisfy Mr. Bruno's request. And I disagree with him that we have an obligation to pursue documents from other departments. I do know that there is a provision in the Business and Tax Regulations Code that says departments should provide us with certain materials when an appeal is filed. I don't see anything in that material, in that Business and Tax Regs that says anything about an obligation on the board. And again, respectfully, I don't believe that it's something for this body to weigh in on. So, thank you.
Okay, thank you. All right, DBI.
I don't have the document in front of me. It was presented to him there.
Here you go.
Thank you. I'd just like to respond on this here.
And go and restart the time for him.
Per this document there, when city planning disapproved the plans, it was brought back to our department in May 8th, 2017, and there was a cancellation request letter that was sent to plan reviewer Ann Hugh, and on May 8th, that day, they canceled the permit. So as soon as the plans came back to us from the planning department, they were canceled. Okay.
Great, thank you.
Yep.
And planning.
Christine Silva, planning staff. I just wanted to reiterate that we received in total 4 requests for records, and we complied with all 4 requests in a timely and complete manner. And further clarify the May 8th date for the original request. It is my understanding that we never received a request on that date for plans, and that was directed to the Department of Building Inspection.
Great, thank you. All right, Mr. Bruno, you have 9 minutes to respond to.
I would like to ask you if you have questions, again, because Cynthia, again, everybody, as far as I can tell, has clarified what is admittedly a complicated process. So the first thing I would like to ask is if you guys have more questions about that process. Without understanding it, it's hard to make a judgment about who had plans and why they're significant and why the original plans were significant. Are there questions about that still? And how this happens regularly with the Board of Appeals, that basically neighborhoods go there, and as Sue Hester, who's a friend and an attorney, has commented recently, the Board of Appeals has recently been regularly legalizing illegal things, and without participation by the neighborhood, that will happen over and over again. We will continue to lose housing, and how you discourage people from participating is making it really hard for them to get plans. When you look at what I've left here on the overhead, you'll see that the original plans I didn't finish before were submitted by the permit holder on August 9th of last year. 2 sets, that's what that 2 means on the top. 2 sets had to be, by law, submitted. And I don't know that once something is canceled, it's destroyed. I'd never heard that, because what the permits department told me in building is that they have to be kept so long as the permit is alive. What what Daniel didn't know is that the permit holder appealed to the Board of Appeals. So the permit was still alive after it had been denied by the planning department. It was alive because there was an appeal. So then you'll see that in January of this year and February, the same permit holder submitted more revisions. Again, none of these were ever given to the public. Whether or not the building department owes those documents to the public, I cannot say because I'm not a lawyer. To me, the easier question is that the Board of Appeals, when you look at the Good Government Guide, when you understand, as City Attorney Herrera states clearly, that the Board of Appeals is one of only 4 quasi-judicial bodies, that the members of the board must act as judges and must look at a complete record. When you look at the context and you look at the particular requirements of what Cynthia referred to as the Business and Tax Regulations Code, that upon receipt of an appeal, the board shall be the duty of the department from which the decision is appealed, that the board receive all the documents. It's the one opportunity because, as Dennis Herrera says, it's a quasi-judicial body. It's like going into court. It's the only opportunity the public might have to ever see plans. Because what's being said here by the building department is perhaps correct, that otherwise they're copyrighted, otherwise they're secretive, otherwise they're part of a work product that is not allowed to be reviewed. I'm not sure what the answer is to that one, but clearly when you go before a court and you have to submit all the documents, you can't have half a record come in. That's what's happened here. Half of a record came in and the public was denied its right to participate because of that. So do you have other questions about the process? Or?
This is your time to
I realize
rebut.
that.
We're not going to be asking questions at this point.
Okay, so I don't have 9 minutes of things to say, but I will point out that, again, the context here was a extremely biased process that we are all facing at the Board of Appeals. It is an extremely unfair process in part because of the failure to allow people to see the complete public record. Let me give just one example of how it was unfair in this case that you should also be concerned about because it's a public information issue. The advocate for this project is a 15-year member of the Board of Examiners. So the advocate, meaning not the owner of the property, but the person himself who was hired by the property owners, is somebody who sits on one of the boards for the city and county and got permission, special permission, to represent these people, even though he's a board member of one of those other quasi-judicial bodies, as City Attorney Herrera calls them. He was their expediter. He presented to the building department and to the Board of Appeals a title for his permit and a title on his plan. This is one of the reasons we wanted to see it, because when you do plans, you have to show the existing conditions that are already there. And the title for his plan was Move Existing Legal garage to center of building. But every group that ever looked at this, the planning department and the building, all said that these were illegal garages, that they had never been made legal by the city. So again, if the city doesn't take control of how words are used in these processes and how records are kept and whether or not people are allowed to see those records, then what you have is a very slanted process that instead of, as the Sunshine Ordinance discusses, instead of encouraging people to participate, instead of encouraging a sense of control by the people over these boards and agencies and departments, it discourages that. And that's exactly what's happened here. If this isn't moved forward and isn't reviewed positively, I believe, by the full task force, then what we have is setting a precedent for simply inviting the Board of Appeals and the planning department and building department together to not encourage people to participate in a very complex process. Admittedly, it's not an easy process. And yet, without that participation, the city would be without a public voice. And with that, I close my comments, and thank you so much for all of your time. Thank you.
Thank you. All right, and now it's to us, guys. Any thoughts?
This was a lot of information, and it was difficult not to go down the rat hole of the whole garage thing, but I don't see any violations here that are sunshine.
Member Eldon?
Well, I don't know. Do you have any sunshine violations?
I mean, so it seems to me that embedded in this narrative was both the sort of problems and weaknesses of the way our existing system works, as well as some inferences to issues that may juxtapose against the Sunshine Ordinance. My problem is that there was so much of a multi-layer of information that it's hard for me to see where the potential sunshine violations occur. I don't think there is a valid argument that the Board of Appeals violated the Sunshine Ordinance by not providing documents they should have had. I do think that a valid argument was made that they should have been in possession of these documents, but to the best of my knowledge, we have never found found a department in violation of the Sunshine Ordinance for not turning over documents they didn't possess. So I don't see a lot of room there. With the Department of Building Inspection, it sounds like there is a process put forward to review these documents. There's even a process that one can embark upon to obtain those documents by getting permission from both the homeowner and the architect. Whether or not those processes happened or not, whether or not those processes are legally justifiable or not, is again an area that the Sunshine Task Force has never dived into in my tenure. Finally, we have the Planning Commission, and we're sort of reduced down to the representative from the Planning Commission was able to cite 4 different records requests that were responded to in a timely fashion. It seems like there's some other requests that you made that preceded those that we don't really have the records in front of. So that's the area that I see as most potential for an actual violation, but I have not seen the evidence to support that at this point in time. The other 2 issues I think are very interesting, but I don't see a solid argument that either one really enters into the dominion of the Sunshine Task Force. So that's where I'm at. Does that seem to comport with what my colleagues are thinking? Do my colleagues disagree with me?
Yeah, I mean, the types of violations that it seems like we're seeing here would be failure to respond in a timely manner, but we just don't have the timelines really nailed down for what those would be in order to say that decisively. So it's like if we had information that spelled out, like, here was what we, so there's like the DBI thing where it was like the October 4th email where Mr. Strawn acknowledged receiving a request for public records and apologized for a delayed response. And that the responsive records were ready. But it just nailing down, was that an IDR, when was that request made, is not something we've been able to do clearly. And given that it was around this whole canceled, there's this cancellation and it went back and forth, that was harder to track down as well. So
I submitted a chronology.
Please,
to all of you. Did you get my chronology?
Please, they're speaking. We don't take questions
I'm sorry.
from the audience.
But I gave you a chronology.
Yes, there is a chronology in the documents. There's just a lot of material to sort through here.
There is like multiple chronologies for each department, so that is what was confusing.
So, Victor, this is probably the first time I recall seeing one file that had 3 different departments as respondents. How did this end up as one complaint and not separate
There was only one complaint file submitted to...
I see. So basically, how many files it turns into isn't really an administrative decision. It's based on how the complainant writes it down.
Yes. It's at your discretion if you'd like to split these into separate complaint files. We could do that, but...
So my gut tells me that, like, we were able to sort of parse through this as one complaint file today, but each of the distinct departments really has a distinct relationship to this case, and I do think, I'd like to hear from my colleagues, but I do think that separating this into 3 case files actually is warranted.
I mean, so...
It's no issue with that.
I mean, as a complainant, are we asking the complainant to resubmit?
No, it would just be done by the administrator.
I would just create 2 additional files and place a complainant into each
Okay. And
a
that would-
respondent into
and
each
then
file, so they can
you're-
be addressed separately.
And then Chair Wolf, you're saying that would be
So the reason
the full task.
everything's going to get sent to the full task force, and I think that basically if we hand this like triple layer sandwich to the full task force, no matter how much we try to break it down into its integral components, it's kind of a mess. And so I think that it may be a lot to lift as 3 items, particularly as we're not seeing a whole lot in any of the individual ones, but I just feel it's going to make it cleaner and easier to deal with.
I support that. I think the key is just, will that help us establish the specific timelines that will determine whether or not there are violations?
It should.
And I believe you did request that the complainant specify specific dates that they submit a request to the planning department and whatever responses they received.
Yeah, and as the complainant moves forward in preparing for the full task force, keep these as 3 completely distinct files. If you have something with the DBI, that goes in the DBI one. If it's with the Board of Appeals, because right now it's just one cluster. Yeah.
Makes sense. Thank you.
So I would like to, I guess, make a motion to...
Just make the motion on the matters themselves, and we can divide the question at a later time, at the end of the meeting.
So I guess my hesitation, I'm inclined to move forward with no recommendation, or we could... I know that Chair Wolf, the chair of the large task force, different Wolf, has wanted us to make sure that everything is clean as possible before it gets to the full task force. What is your recommendation in terms of, do we need to go back to us?
It sounds like we have a good description of each item to present to the full task force. I believe you do have that. We can refer to the full task with no recommendation, and we could provide a summary regarding each department, and we can divide the file into separate files. So
Sure. So I'd like to go ahead and make that motion. The reason I'm making a motion for no recommendation as opposed to no violation is that I do not have confidence that there's no violation. It still feels like a sea of facts that need to get sorted, and I'd rather not bias the larger task members until that sorting process is done. Is there a second?
I'll second that.
And can I include a finding of jurisdiction and that
Yes, please.
the departments the records requested are public records?
Yes. Well, wait. One of the records requested is not a public document, potentially.
Well, it became uncanceled.
Well, but there's still the canceled and the uncanceled permit, though. There is a document in here that may or may not be
with
public.
the provision that one of them may not be disclosable due to copyright laws.
Great. Thank you.
That was motion made by Member Wolf, Chair Wolf, seconded by Member Eldon.
Is there any public comment? Does my colleague have something to say?
No, I just was wondering where we were.
Okay, the motion stands to make that motion and to divide the file into 3 separate files, one for each department. On that motion, Member Eldon.
Aye.
Eldon, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Chair Wolf, aye. That motion passes. This matter will be referred to the full task force. Parties will be notified once that matter is scheduled.
Great, thank you.
Can I have 2 minutes to listen to my 89-year-old father's voicemail?
Sure, my brain
Make sure
is...
it's actually...
Sure, we will be in a short recess.
We'll take a 1-minute break.
We're back on the record.
He's all mad because they took away his night driving license. I'm like, Dad, I would have taken away your night driving license.
He needs a self-driving test.
Next on the agenda is item number 9, file number 17104, complaint filed by Kathleen Courtney and the Russian Hill Community Association against Nicholas Foster and the Planning Department for allegedly violating Administrative Code, Section 67.21, by failing to respond to requests for public records in a timely and/or complete manner.
Chair Wolf, Kathleen Courtney, Russian Hill Community Association. It's all about process, and you're going to have a little sense of deja vu with me right here. We submitted, John Baruso submitted 4 different requests for public information on a project at 60 Russell Street. Jonas Ionen replied that all requests were fulfilled and the planning department was in compliance. We then provided Mr. Ionin with a copy of the first record request, which did not have a file number on it, and he admitted that he acknowledged that, in fact, the planning department did not fulfill the records request under the Sunshine Ordinance. And we appreciate his acknowledgement very much, because the concession allows us to talk about the remedial actions that we would like to see. But just to go on the record, no one believes that anyone in the planning staff willfully withheld this vital document from the neighbors. We don't believe Mr. Ionin or anyone did it willfully. But it's something that's been happening in the planning department on an ongoing basis. The planning department has a system called the Planning Information Map, and planners are required to, or planners upload their documents as they author them to the Planning Information Map, or when a project is completed, it goes to the Planning Information Map, or some do or some don't. But the Planning Information Map is an online way that people can access information about a property. That did not occur. What happened here was that the planner left the department, and the vital document was not available for 2 years, either online or under the Sunshine Ordinance. This was after 2 Planning Commission hearings and 2 Board of Appeals. And this is the point. Until there is an explicit directive from the planning director that requires all planners to upload their documents on the Planning Information Map, the public will continue to suffer through a lack of publicly available information. The lack of documents results in poor land use decisions based on misleading or incorrect information, and it hurts us all. The department's current retention rules are incomplete, out of date, and wholly unenforced. I want to emphasize that it's not Mr. Ionin's problem, or it's not his responsibility. The planners do not report to him. He has no control over what they do. It's the hierarchy at the planning department. Give me one more second, real quick.
Go ahead.
Members of the public have been appearing before the Planning Commission for the last 3 or more years and talking in public testimony, the public comment period, asking that the planning department produce comprehensive, transparent, and publicly accessible procedures on their administrative functions, which includes permits and detailed document retention requirements. This has not been done. It is required. It is the only way that the citizens of this city are going to be able to access data. Thank you very much.
Great, thank you. And Ms. Silva, because they got an extra minute, we'll give you an extra minute as well.
Thank you. Christine Silva, planning staff. This is in response to file 17104 filed by Kathleen Courtney against the planning department as related to a proposed development project at 60 Russell Street. Our records indicate that John Baruso submitted 4 requests to staff. The first request was submitted March 17, 2016, requesting all documents. 4 days later, on March 21st, planning staff, Josephine Chen, provided the compiled records at a reception desk. A second request was received via email on May 19th of 2016, also requesting all documents. 7 days later, on May 26th, planning staff, Josephine Chen, then again provided the compiled records to the requester. The third request was submitted via email on June 10th, 2016, requesting NOPDRs and RDT memos or notices. That same day, planning staff Nicholas Foster emailed the PDFs of the requested documents. And then the final request, which was submitted March 31st of this year, requesting correspondence, to which planning staff produced those records 4 days later on April 4th via an email download link. The complainant alleges that planning is in violation of Admin Code Section 67.21 by failing to respond to a request in a timely and/or complete manner, specifically as related to a document for a project review meeting that recently appeared on Planning's SF Property Information Map website, the website that the complainant just described. The department acknowledges that this document was inadvertently omitted from the record productions on March 17, 2016 and May 19, 2016, when all records were requested. It is our understanding that staff believed that she was producing the entire set of records at both times of production, and in no way was it a deliberate action to not produce it. Upon further review with our IT staff, it appears that there was a glitch in our website, which was not correctly exposing the project review document. IT staff further confirmed that the glitch was corrected when our office launched the related documents link feature on August 3rd of this year. At this time, all responsive records have been made available to the complainant.
Great, thank you. And Ms. Silva, can you speak to what that glitch was? Do you know, in any technical terms, how that transpired?
So each document in our database has a classification, like a correspondence, an internal review document, notices, etc. This particular document, the project review document, was titled or was classified as an internal review document. And for some reason, all of the documents that were given that classification were not exposed on our external website. IT wasn't able to figure out why that was, but they did correct it. That was in August of this year.
And when they corrected it, was there any stats created of how many documents were now made publicly available that previously people might not have known existed?
They were unable to find that information because on August 3rd, what we did was we launched what's called the Related Documents link. So this link allows the public to view basically any electronic document that is attached to a project. And so it was kind of like on and off for all of the documents, regardless of their classification, which also included the internal.
Right, so you created a whole new avenue that people see these documents that had been obscured. And I don't know whether this is necessarily within our jurisdiction, but it seems like if you were to look up how many documents have the internal review classification, that would be the population of documents that were not readily accessible until this glitch was discovered. So I don't know whether that really matters for our purposes, but if this comes back in the future, it would be helpful for us to be able to know, like, there was 1,000 documents that for 2 years were not visible on the web, so that we can, like, address that moving forward. This is how this happened and that sort of thing. But again, I don't know whether that's really within the scope of this case. So basically what happened was there was a document that, due to marking it as internal review, even though it was still a public record, it was marked not publicly visible on the website, and then sort of didn't exist for 2 years, because when people would request the documents, you just take what was listed on that same file and turn it over, and it just sat inside this sort of no man's land. Is that an accurate assessment?
Correct, yeah.
Great. That's all the questions I have. Anyone else?
Is this rebuttal?
We are not quite to rebuttal. We're at the, if we have questions for you time, we'll ask them, and then we'll get to rebuttal. But it's looking like I'm not seeing questions from anyone, so we'll go ahead and... Are you just preparing for rebuttal? Okay.
Well, question for us. Do we have any way of... do we just incorporate technical bugs, glitches that deny documents into the standard violations? Have you...
We've had a bunch of those. If I may, usually they've been, Outlook email that went to either trash or junk or out of offices that went in. Yeah.
The document wasn't provided. It doesn't really matter whether it was... I guess if it was intentional, that would matter because it would create a willful violation, but it doesn't really matter whether they just didn't see it or it was hidden inside some weird space. It still wasn't provided. So I think that the technical glitch doesn't really change what would be found inside there for the violation or potential violations. Should we move to rebuttals? All right. If the representative from planning can go ahead and make any rebuttals if you have them, or...
Just to reiterate that when we did produce records on March 17th and March 19th, which were the first two requests where they requested all records, it was our understanding that staff believed she was producing the entire set of records both of those times. And in no way was it deliberate to not produce the project review document. And again, that we caught the glitch and we've corrected it, and now the document and other related documents that are also classified as internal review docs have been properly set so that they are exposed to the public.
Great, thank you. And now's your opportunity for your closing statements.
Our contention is that the department's current document retention rules are incomplete, out of date, and wholly unenforced. There's no written procedures. The way that the planners handle it is haphazard at best. In his response, Mr. Iona noted that the first request specified the file number and no data was submitted when the first that the file number was stipulated. In the first request, there was no file number, and it was listed, and I don't know where it would have been listed internal, but it's listed general information right up in the corner. Again, there are no written procedures. If there's an issue like the prior complainant noted that he submitted a request and nobody can find it, this is the request that planning was unable to find, and we presented it. We went back and found it. What we are asking is that the Sunshine Ordinance Task Force direct the planning director to provide written documentation so that the staff can follow it and that the staff can timely upload information to the planning property management or information mapping system, because without that online access, the community cannot track what's going on. Thank you very much.
Thank you. And Victor, is the request that Ms. Courtney made at the tail end there something that would be followed through on by the EOTC or the Compliance and Amendments?
That would be done by the full task force, and
no, I mean following up with the Planning Commission around changing the way they operate.
I believe that would be a letter authorized by the full task force. You can make that recommendation to the full task force to issue such a letter, and the full task force can comply, not comply,
great,
and
all right,
so forth.
Great. Does anyone feel inclined to make a motion at this point?
You do have one violation, right? I mean, it was a failure to respond.
6721?
Yeah.
I would suggest fail to respond in a complete manner.
Yeah,
And
let's go with
not
complete.
regarding timeliness. Well, it would be timely because
Do we have does 21 have a,
it covers both.
no, but 21's got, I know it's got like A through,
We can just list the whole section.
Whole
we don't
Megillah?
we don't need to get into this.
I mean, particularly from the committee, not the actual motion, I think 6721 is sufficient.
I would say 6721, and then I would specifically put in the motion for not responding in a complete manner. Is that what you were suggesting?
Yes.
Mr. Young, thank you.
Yes.
I'll second that.
Would you like to include any suggestions to them?
What about the matter of records retention that they were raising?
I did not think of that.
I think that's an important thing to be discussed at the upcoming meeting, but I'm not entirely sure that it should be part of our motion so much as a direction to our chair to look at that. But if people feel more comfortable with that as a motion, I'm happy to change my second to incorporate that.
I'm just trying to follow through what they were looking for here.
It could be a motion to.
Well, I don't know that the case is made as clearly for the records retention. That wasn't as, I mean, besides the technical error that has since been fixed, it wasn't really the focus of this complaint as much as the inability to get the key information that they.
I mean, I suspect that Ms. Courtney has more to argue around why the records retention needs to be changed. I'm just looking at the best way for us to. Would it make sense to do two separate motions, one around the violation and one about the letter, so that they come to our chair as two separate things?
I don't think that would make a difference when it gets to the full task force.
Okay, I'm just.
We can make the recommendation to refer the matter with. The motion to refer the matter to the full task force with a recommendation to find a violation of 67.21 for time for completeness, and to suggest that a letter be written to the Director of Planning regarding records retention policy or something.
Sure. I mean, I would rather have the motion be for the full task force to explore the retention policies and make a letter as appropriate, because I don't feel quite
we can do that.
ready to make the recommendation for the letter yet.
It was just part of the complaint. I don't just.
It wouldn't be.
We nailed
We
it.
can just suggest to the full task force to explore that further at the meeting.
That sounds good to me. You're the motion
Yeah, I'm
maker.
okay.
Cool.
Who may I ask who made the motion again?
I think I made it.
I seconded it. Oh wait, you seconded it?
You seconded
I
it.
thought I seconded it.
Can you repeat the motion to make sure it came out the way I made it?
And I would like to actually add to that motion. The motion is to find that the task force has jurisdiction over the records in question, and that they are public records, and to refer the matter to the full task force with the recommendation to find a violation of 67.21 for failure to provide complete records.
Yep.
And to suggest that the full task force explore the issue of the possibility of issuing a letter regarding records retention.
Pertaining to the planning department.
Planning department. Pertaining to planning.
Right. All right. Is there any public comment on that motion?
There does not appear to be any.
All right. Go ahead and call the roll.
On that motion, Member Fisher.
Aye.
Fisher, aye. Member Eldon.
Aye.
Eldon, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. Next on the agenda, item number 10, announcements, comments, questions, future agenda items, and pending calendar by members of the Education, Outreach, and Training Committee.
Does anyone have anything to add here?
How's John doing?
I don't have anything to share.
Next on the agenda is adjournment.
All right. By acclamation, adjourned. Adjourned.